Good morning, everybody. Thank you for being here with us. Last count that I saw is we have about 201 people online right now, which is amazing. So thank you all for being here. And I've got to ask, is anybody else just slightly worried about the fact that it's Friday the 13th in 2020? Because I am, and I'm standing right next to a window that's partially open, and I'm half expecting murder hornets to come flying through there any moment now. So let's hope that doesn't happen. But anyway, my name is Josh Randlett, and I am here to talk to you about updates at the Maine Human Rights Commission and in general litigation about employment-related matters. I've got a PowerPoint to share with you, and I will preface this by saying, I know that you're not supposed to put a ton of text on PowerPoint slides. I tell myself every year that I'm not going to do it. And every year when I sit down to do it, I just can't help myself. It's part of being a lawyer. We are verbose. We like to write. So I apologize for all the text that you're going to see. But I thought it might be helpful for you to have that information. So in terms of the Human Rights Commission itself, I wanted to start by just going over some of the data that they publish annually about the types of cases that they're getting, the amounts of cases, what they're doing with them, because I find that stuff interesting. And so the data that I've got here is actually the 2019 data. This was published after our meeting last year in 2019. So this is new for our purposes. And I don't believe the 2020 is out yet. But in all, in calendar year 2019, they had 715 new complaints, which is pretty consistent with what they had the year prior. It's only about a 1% increase. So it's not much of a change there. In terms of the types of cases that they're getting, the overwhelming majority of them are employment related, about almost 67%. So you got more than 2/3 there that are employment related cases. The next largest category after that is public accommodations, which is 16-point-something%. And then it goes down from there for housing, education, and extension of credit. So by and large, that's the bulk of what they're doing at the Human Rights Commission is employment related cases. When you break down the data to the employment cases, it's interesting to see what the most frequent complaints are that they're receiving. So the most common category is disability. And the data is a little tricky here because in a lot of cases, there will be more than one allegation. So you might have disability with a retaliation or a sex discrimination with a retaliation or whatever the case may be. But this is the data that they were able to put together for us. Almost half of the cases have to do with some form of disability discrimination. That's the largest category. Following pretty closely behind that, though, at almost 39% is Maine Human Rights Act retaliation. And as you all know, that is a claim by somebody who says that they spoke out in opposition to some form of discrimination or they made a claim under the Human Rights Act, and then they were punished or retaliated against for having exercised those rights. And I think that's an important thing to keep in mind, that this is a very frequent claim that they're seeing there for when you're dealing with somebody who has made some sort of report or claim or opposed some sort of discriminatory practice. Just bear in mind the frequency with which these claims are made. And I'm not saying handle people with kid gloves or don't impose appropriate discipline if somebody has raised those sorts of issues. But you want to be mindful of it. You want to make sure that if this person is in line for some sort of discipline for whatever reason, that you've thought through it beforehand and that you've documented it all very well so that in the event they later turn around and say, well, I wasn't really disciplined because I was late 27 days in a row. It's because I spoke out that one time. You've got the documentation there to back up and show, no, that had nothing to do with it. It was because of this attendance issue. Following very closely behind Human Rights Act retaliation is whistleblower retaliation, a little over 1/3 of the cases. So again, same issue there. Be cognizant of it. Not that any of you would ever retaliate against anybody, but just make sure that you're thinking through the process and documenting as you go. And then in roughly 1/4 of the cases, they see some form of sex or gender discrimination. And in over 1/3 of those, it's harassment-based. Hostile work environment type claims. In terms of disposition of cases, almost 2/3 of them are resolved before they ever get to the final public hearing, which is before all the commissioners down in Augusta. Some of you may know that the Human Rights Commission in the last few years has really put a lot of focus on their voluntary mediation program. Some of you may have participated in that. I've participated in that. I think it's a wonderful program that they offer, and it looks like that it's being pretty successful. It's got nearly a 2/3 success rate for cases that go there. So that's some interesting data there. And if you've been through that process, you probably know that when you sign up for the mediation, you have to sign a piece of paper basically saying that in exchange for using their process, you will tell the Human Rights Commission the amount of money, if any, that the case settled for. So through that, they were able to discern that in 2019, there were monetary settlements through that process of just under $3 million, 2.929 million, which is quite a lot of money. So that I just found that interesting. In terms of other dispositions, looks like they've got 163 settlements across the board, 132 right to sue letters that have been issued, and 147 administrative dismissals, which I found interesting because I didn't think it was going to be that high. The administrative dismissals are broken down even further, with about 77 dismissed for lack of jurisdiction and 70 dismissed due to the claimant's failure to cooperate in the process or to respond to inquiries. And in only about 37% of cases, investigators completed their investigation and issued a report. So just over 1/3 of cases make it to that point. In cases where investigators do actually write their report, reasonable grounds are only found in less than 20%, 16.8% have reasonable ground findings to be exact. That's up slightly, about 3% from last year, but it's still surprising how frequently they have no reasonable grounds findings, which is interesting. And in 2019, there were only 93 cases that actually went to a contested public argument before the Human Rights Commission itself. For the cases that did go all the way through a hearing, there was conciliation that was successful in 10 of those, and that resulted in about $44,000 of monetary relief, plus who knows what for equitable relief. And then in terms of, as you probably all know, the Human Rights Commission itself can file a lawsuit in cases where it deems it appropriate. There were 5 cases referred to the Commission Council for litigation in 2019, only one of which actually resulted in them filing a new complaint. And then they filed an amicus brief in one other case. And as of the end of 2019, the Commission itself had 3 pending cases in which it was a party. So that's my data update on the Human Rights Commission. In terms of the Human Rights Act itself, it's been a pretty quiet year. You might recall that last year we had a number of updates about amendments to the law. This year, due to the legislative cycle we're in, there really haven't been a lot of changes. There was one bill from 2019 that got carried over. It's an act to improve consistency within the MHRA. That made its way to Governor Mills's desk, but then was pulled and amended further and carried over to the next session in 2021. And that doesn't really do a whole lot that impacts our purposes here today. It clarifies that gender identity is included as a protected class for employment discrimination purposes, but that's no real surprise to any of us. I think we've all been operating with that understanding for a long time now. And then it also includes a definition update to familial status to include adult dependents who live with their parents or guardians as a protected class as well. So somebody who's an adult but is disabled for one reason or another, not able to care for themselves. Again, I don't think that's much of a game changer, and I think people had understood that for a while now, but it is going to be reflected if this passes in the act itself. This has been an interesting thing in 2020. As you all may know, OSHA has jurisdiction to handle and resolve whistleblower complaints about COVID-19 issues. So an employee who thinks that they've been discriminated against or retaliated against for having told their employer, I don't think that you're following the proper protocols or this, that, and the other thing, those complaints can go to OSHA. And OSHA has actually been swamped with these things in 2020. As of last week, the latest data that I saw, there were a total of 3,329 OSHA whistleblower complaints filed just about COVID-19. In about 50% of those, they were screened and dismissed right off the bat without any investigation. About 724 were docketed for investigation. 704 were referred to state plans. We don't have one of those in Maine, but certain states have work sharing agreements with OSHA to resolve these things. And as of November 9th, there were 224 of these OSHA complaints still pending. If you find yourself in the unfortunate situation of having an investigation in this, it is not a fast process. The average time frame from intake to resolution, this is as of October 2020, is about 280 days, give or take. And I've actually got a case pending with OSHA right now on this, and I can attest to the fact it is a slow and arduous process. In terms of case law update, again, it's been a fairly quiet year. I have a few cases that I'd like to quickly go over. How am I doing on time, Karen? 5 minutes, perfect. So I've got 3 cases that I'd like to quickly talk about. One is Trahan versus Wayfair, Maine. And the facts here, the employee was a military veteran and she had PTSD. And she worked in a call center in close proximity to other people. She didn't tell her boss or anybody about her PTSD diagnosis. And she had a workplace, the workplace had a rule about treating people professionally and respectfully. Well, one day the employee was talking to one of her coworkers and another coworker interjected into the situation. And the employee thought that that was rude, the way that happened, and told the person who interjected not to be ignorant, and then threw her headset down and stormed off and made a bit of a scene. HR investigated the incident. The employee kind of admitted what happened, but said that her coworkers were in a clique and she didn't like the way that they treated him. And she called them a bunch of expletives. Won't get into that, but she told that to HR, which is not a very wise move to make. She also crossed her arms, stared at the wall, rolled her eyes, goes on through the investigation process. Her conduct is substantiated. Turns out HR is telling her, look, we're probably going to have to take some action here. And then lo and behold, how many of you have had this happen? She discloses at the 11th hour, wait a minute, I've got a disability. I have PTSD. It was triggered by the way I was being treated by my coworkers. You can't discipline me. The employer went ahead, did discipline anyway, which is a termination. The employee filed suit for ADA discrimination. The First Circuit held in favor of the employer, and they had some very favorable language there. It's not anything new, but it's good to keep in mind. The ADA is not a license for insubordination in the workplace, and the employee's emotional outburst plainly demonstrated her breach of conduct rules. So basically, an ADA accommodation request doesn't excuse past conduct, and you can't use it as a get out of jail free card. Another case I want to briefly talk about is Bell versus OReilly. This employee worked at a car dealership. He was a manager. He had to work about 50 hours a week, and he had a number of disabilities. He had Tourette's, he had ADHD, he had depression, and when he started, it was 50-hour-a-week job, but due to people leaving, often found himself working 100+ hours a week, which exacerbated his medical condition, and he was in pretty rough shape. So he got a note from his doctor saying that he should not be scheduled to work more than 50 hours a week, or perhaps 45, something along those lines. Presented that to the employer. The employer said, we can't accommodate that. Number one, we think you're doing a fine job by yourself right now. We don't think you need an accommodation, but anyway, we need you to work more than 50 hours a week. So you can't perform the essential functions under that restriction. The employee filed suit, went all the way to the First Circuit. The employee won. And there's a couple of important points here. The most important thing is the First Circuit said that an employee does not have to prove that they need an accommodation to perform their essential functions of their job. They could be entitled to an accommodation if it would be effective to assist them to perform their essential functions. So even if they can technically do it without an accommodation, if there's a reasonable accommodation out there that will make it easier and more effective for them to do it, they might be entitled to that. So you can't just deny it flat up on the grounds that we think that you're doing fine and we don't think you need this. And then the judge said it was up to the jury to decide whether or not one of the essential functions was actually to work 100 hours a week. So that case went back to the jury for another trial. And then the last one, this is brief, I've only got a minute left. This is a case that Brent and myself, and if you recall Frank McGuire from years prior, this was our case, Young versus Maine Coast Memorial Hospital. There's a lot going on in this case, but one of the issues was workplace policy, which the National Labor Relations Board thought was overbroad. And the hospital in this case put in a savings clause, which basically specifically carved out and said, this policy does not prohibit or restrict anything that's protected by Section 7 of the NLRA. The National Labor Relations Board did not think that was effective. They wanted to be more specific about what exactly was protected, when it would apply, when it would not apply. They thought it was too broad. That went all the way to the National Labor Relations Board itself down in DC, who agreed with us that the savings clause was sufficient, which is good news. So to the extent you have workplace policies addressing social media, interactions with the media, workplace civility, might not be a bad idea to put a savings clause like that in there just to be safe. And I'm being told I have used all my time. So I will now pass off to my colleague, John Hamer, who will be talking to you about updates at the NLRB. Thank you.